Hi, on today's Q&A, we're going to go over the common question of, am I going to jail? This is something that nearly everyone that comes to our office asks us, and there's three types of considerations that we need to take in mind before we can answer this question. One is just general considerations, the other is the statutory considerations, and the third is a little bit about the background of the person asking the question. At the outset, no lawyer is going to be able to guarantee that you will not go to jail if you are being investigated or charged with a crime that has a potential jail sentence. We're not psychics. We can't make guarantees. The best that I can do is say, in my personal experience, based on this type of case, based on this type of evidence, with who you are as a person, I don't think you should go to jail. But I can never guarantee it. The next consideration is to whether or not the state is even offering a plea bargain. I can tell you that you're not going to go to jail when I know you have been extended a plea bargain that does not require you to go to jail, and I know the judge is going to accept it. It's almost like in this case, we have a pre-arranged or pre-agreement or agreement in principle on a contract, and which is what a plea bargain is. But that's something that has to be extended to you by the prosecutor. It has to be something that's accepted by the court. And if it is, and you do what you need to do, you'll be put on probation and you won't go to jail. That said, we also have to look at the statutory elements of any particular crime. You can be the greatest person in the world, never been arrested before, and you come and you sit in my office and you tell me that you're being investigated for first or second degree murder. I will tell you that if you're convicted of that, there's no way you're not going to jail because the law requires jail. Same thing for felon with a firearm, same thing for armed robbery, same thing for many sex crimes, same thing for even certain types of drug distribution cases. So there are certain crimes that if you are convicted of that serious crime, you have to go to jail, and it does not matter what you've done in life up to this point. Now, those may be plea bargained down to something that doesn't allow you to go to jail, but as you sit right there in that moment, certain crimes require jail. Another type of statutory consideration we must consider is people who have potential habitual offender adjudications, or the multi-bill. You can be sitting in my office charged with a forgery and have a prior drug possession offense. If the state chooses to enhance your sentence as a habitual offender, it doesn't matter how small the felony amount for the forgery is. It doesn't matter if you've paid it back. It doesn't matter if you've gotten your life together with substance abuse treatment or any good things that have happened to you since the arrest. You have to go to jail. Habitual offender law creates a mandatory minimum sentence, and it eliminates good time. So your only release would be on parole. So we have to look at that statutory consideration. And the third thing is obviously your criminal history. There are certain people who have too many felony convictions to put them on probation. As a general rule, historically in Louisiana, you can only be put on felony probation twice. That has expanded to certain drugs and DWI convictions that allow for a third or subsequent conviction to be probated. So those are the factors to consider to the question of, am I going to jail?